cause number PD 061623, Larry Gene Strickland II versus the State of Texas.
Good morning, and may it please the court. I'm John Messinger, Assistant State Prosecuting Attorney on this case out of Hood County. Article 4208 says that a trial court has discretion to stack a new sentence on top of an old sentence. The statute doesn't say anything about the specificity that has to be in the judgment. It doesn't say that there's any fact-finding that needs to be done. And in fact, this court has made it clear that there is no fact-finding, that it's entirely a normative decision, and that a lawful accumulation order is unassailable on appeal. Yet this court sanctions the assailing of multiple stacking orders for various reasons. One of them is for lack of an unspecified level of specificity in the judgment, and also for having inadequate record proof to show that the defendant does in fact have a prior conviction. This is not a new issue. This court's granted review of this issue in 2000 and again in 2006, and has been flirting with the idea of having a remedy, because there is no remedy at this point other than striking the order. The court's been flirting with a remedy for 25 years. I think this is the time to take the opportunity and clean this up and go back to what the statute requires.
Do we have to overrule any prior decisions of our case? I mean, do we have to overrule any prior decisions in order to agree with your position?
Yes, many of them. Depending on how you interpret the statute, it's been written as a discretionary statute since 1919. It was non-discretionary going back to 1879. So either way, there's a lot of water under the bridge. The problem is if you want to call it a prophylaxis, what we've built onto the statute isn't dictated by the statute. And it's been at odds with how this court has been addressing similar issues and things like preservation and error classification more broadly since the mid-90s. So it's become unsustainable if it was a good idea at some point in the past.
When you characterize what we have to overrule as many opinions, it kind of makes it hard to figure out what specific language in any specific opinion is in conflict with what the statute would otherwise require. Can you be more specific about some language that maybe has appeared more than once that is the problematic language?
Sure. Well, the overarching body of law that says that the accumulation order, which is in modern parlance that portion of the judgment that says that it's going to be, the sentences are going to be served either concurrently or consecutively, that goes back to the late 1800s, that there has to be specific language in there that says what is the prior conviction you're stacking it upon. And there's a preferred list of 5 descriptors of what the prior judgment is. It's exactly what you think it would be: the county, the court, the offense, the cause number, the date, and that would be the preferred way of doing things.
Hasn't the court described them as recommended, though, in the past? I mean, if they're only recommended, then...
This court has never, if it did at the beginning, it has been a long time since the court has required all 5 of those identifiers. What they require is some combination of identifiers or some exception, like both convictions came out of the same court, and that's on the record, or a judicial notice exception, but some combination of information on the judgment that would allow, and the current rationalization is allow TDCJ to look at the face of the judgment and understand the order that sentences are to be served. And that's something that the court has been consistent with. Again, the rationale over 100 years ago was the form books say to do it, and it's a preferred practice. Middle of last century, the rationalization was we need TDCJ to know what's going on, and that's been one that's been cited repeatedly since then.
To the degree that it may be insufficient for TDCJ, does the defendant have standing to even raise an argument that TDCJ can't understand this, or would we want to hear that from TDCJ?
If you heard it from TDCJ, I don't know why you would take the complaint. So the short version is, I don't know what right a defendant has to have a judgment that can be easily read by a third party. And when it comes down to the propriety of the stacking itself, whether or not the stacking order violates 303A, this court has said that's an individual right. It's not an absolute systemic right. And that's why I would go back to just basically how we've been looking at preservation since at least Marin in '93. What is the right we're talking about, and why shouldn't you have to say something about it at trial? Certainly, I think the defendant should have knowledge of the order in which his convictions are going to be served. And we have an oral pronouncement rule which gives them the opportunity to object, and we have to have an oral pronouncement rule because if you walk out the door without the judge saying anything about your sentence not starting today, it starts today. And you can't go back and stack an already commenced sentence on an older sentence. So we have oral pronouncement, and the defendant has every opportunity to say something at a time when it would do use to the court. Right now, we have a windfall scenario. Under the current state of the law, you can listen to the judge make an announcement. You can know exactly what the judge is talking about. Surely the defendant knows he's currently in prison. The judge knows he's been benched back for the new trial. Everybody there knows he's serving at least one sentence. And if you think you don't hear the magic words from the judge, you can just keep your mouth shut and wait till appeal, and you can raise it on appeal. And at that point, the remedy isn't to send it back to the judge to make a more specific pronouncement or put more evidence in the judgment. You just strike the accumulation order. So all of the authority that the legislature has given the judge to stack, it goes out the window without an opportunity to fix it.
What would happen in a situation where, say, a trial court was not strictly as clear about the sentence he was imposing? For example, let's say second-degree felony conviction, the judge says, I'm sentencing you to years in the Texas Department of Criminal Justice. And the judgment reflects that as well, but doesn't contain a number. What would our remedy be under that situation?
I mean, if the oral pronouncement didn't have a term of years, you would have...
Said years, I mean, said...
So presumably
none.
some time, right. So if he pronounces that you will be in there for some amount of time, and there isn't an amount of time, it needs to be sent back because that's not a proper sentence. And you might even send it back for resentencing for an entire hearing. But at the very least, you would say, clearly you had a number in mind and maybe you forgot to say it. And that's what would happen. We would allow the judge the opportunity to fix it because it's clear you wanted jail time or prison time. And we just don't know. And this is what happens with restitution. I mean, what this court's body of law on restitution puts a very fine point on this. Findings of fact in the record, well, not findings, but supporting evidence in the record to support the restitution amount is required by statute. And this court has held that restitution is, in fact, a punishment issue, whereas accumulation is just a relationship between two sentences. So restitution is a punishment issue. Evidence is required by statute, and this court requires the defendant to object if they see a problem with how restitution is being ordered. And if they object and they're correct about the lack of proof to support it, the remedy is not to strike it. The remedy is to send it back to take more evidence. And that's what should be happening here. At the very least, a judge should be given the opportunity to clarify what he or she meant.
Is accumulation order a part of the sentence, or is it something different?
It's something different. If you run through 4201, there's the offense of conviction. I think there are 34 things just in 4201A that should be in the judgment. One of them is the sentence, the term of years. Another one is the order required by 4208 to establish the order that sentences are served. So it's not part of the sentence, but it is how these sentences are to be served, which overlaps with the definition of sentence in 4202, but clearly in the context of 4201, there's the term of years, and then there's how that term of years relates to a prior term of years.
So your remedy ultimately would be to ship it back for clarification? Or are you suggesting a judgment no proton?
Well, one, I think this record is clear enough. And I think that when it's clear that the judge wants to stack and the judge is giving a cause number and a prior offense of conviction that I think appellant should be aware that he's currently serving, I think appellant should have objected if he wanted more specificity. If this court is not going to impose a preservation requirement like it does with restitution, and you don't think that the judge's reference is clear enough for somebody at TDCJ to figure it out, then the remedy would either be to send it back. I would say send it back for clarification. I mean, again, there are two separate errors that this court has been running. For the longest time, the problem was just the specificity of the order. And it's a hyper-technical requirement. That's kind of fallen by the wayside. And so what's happened in the last 40 years is the shift has been, well, there isn't enough record evidence. And for a while there, the court hung its hat on lack of authority. Well, if you don't prove that there's a prior sentence, the judge has no authority. But Barrow and Beatty make it clear that authority comes from the statute, not from some triggering fact. So then in Moore, the court shifted to, well, it's a sufficiency thing, and sufficiency doesn't need to be preserved. But in either event, if there isn't enough evidence in the record, you can send like restitution. Just say, okay, which prior conviction are you talking about? And if the problem is the order itself, well, the judge has made it clear it's this cause number, this offense. That judge presumably can get the information. He had something in mind. He can fill out the rest of the order, and then everybody knows what's going on. I mean, that's the problem. An appellant did not object to having any notice, and the argument still isn't, gosh, I don't know in what order my sentences are being served. The entire complaint is, there's a mechanism in appellate law where I can have my cumulation order struck because there's some information missing, not enough to meet some threshold. We don't need all the elements, but in this case, we don't think there's enough elements. So it's a windfall, and that's what they're going for here. So
We talked about, or you talked about the failure to object. Does the trial court have discretion to do this without a request for stacking?
yes, and that's what's interesting about this case. The judge has complete discretion to do whatever he or she wants to do, with or without a request. Most of the cases involve a request. And so a lot of the cases, like the seminal case, 1987's Turner, talks about how weird it is to ask the state or to ask the defendant to have a burden when it's the state that's moving for cumulation. And those cases, it's just a coincidence that the state was moving. And generally, when a party moves for something, they have some sort of burden. But the fact of the matter is the judge could have done it just because it was Wednesday. And so if you want to object to the accumulation, that's the time to do it. And I should point out that there was an objection in this case, but the objection was the state didn't request it. There was no objection to, I don't have a prior conviction, or I have multiple prior convictions. Which one is it because I need more clarity? It was they didn't ask for it, and you shouldn't be able to do it, and that's not a valid objection. And they came back in a motion for new trial, and in the motion for new trial, the complaint was, look, I had a couple technical violations, and you maxed me out with 10 to do and then stacked it, and that doesn't seem right. It also wasn't an objection to some sort of underlying deficiency in notice, if such an interest exists.
Do you think that if a trial judge, we talked about the fact that a sentence begins to run whenever it's pronounced in open court. Do you think that's true even when in the same moment, the trial judge signals that he wants this sentence to be stacked upon some other sentence so that it's clear to everybody in the room that it's not to take effect immediately, but only upon the expiration of some other judgment, whatever that one might be?
That's right. The judge is making it clear that you're not starting this new sentence today. And that would be the point if you're confused as to when the new sentence starts, is to say something. Because I don't think anybody has a greater interest in knowing how much time he's serving than the defendant. And if he's confused, that would be the time, and that's what we've done here. Preservation, broadly speaking, is talked of in terms of a judge protecting procedure, and it also protects the system. The legislature, a long time ago, went to lengths to say, first off, if you convict, the first version of the statute was you've convicted 2 offenses in the same term of court, stacking's mandatory. And then in 1919, they made it discretionary, but they put in no limitations on it. And so it's up to the judges, the elected judges in their district. And when a judge exercises their authority, and according to this court, it's lawful authority because it is authorized by statute, then there should be no other common law built onto it that thwarts that authority. And if the policy rationale behind it is we would like the judgments to be written better, then remand to have the judgment touched up. If there's not enough evidence in the record for the court to modify it, then send it back and say, look, this is clearly what you were going for. And as long as the judge can build out the prior conviction that he believed existed and is at least partially reflected in the judgment, then we don't have a problem. If there are no other questions, I'll sit down.
Thank you, Counsel.
Thank you.
May it please the court, my name is Jeff Shearer, and I'm here with Mark Bennett today on behalf of Mr. Strickland. I will be splitting 10 minutes of my time with Mr. Bennett, and thus I may defer a question or two to him from the panel, just so the panel is aware. This case can be described with one word, and that word is breathtaking. I used to think of breathtaking in a positive light for major events in my life, such as the birth of my children, or when I passed the bar exam, or when my wife agreed to marry me. But here, I view it in a frightening light, which is someone can be stacked with an alleged sentence using nothing more than a cause number. The court below, in this case, got it correct with over a century's worth of precedent where we formed an improper and unlawful accumulation order into a concurrent sentence. And the state has not met its burden to justify overruling over a century's worth of precedent by demonstrating that it's manifestly absurd or unjust. The state says this entire scheme of law is unworkable, but it doesn't provide any data to justify its position.
Can you point to some specific language in some specific opinion that would need to be overruled in order for the court to go with the state's argument here? Because, I've looked through your briefs and, I'm trying to figure it out, so help me out there.
Well, I think one of the major ones, Judge, I believe it was Ex parte Carter, said that this type of error is a Category 2 Marin right and it's not waivable. So I think that's probably one of the biggest.
So what specific language, though? Because, language can mean one thing when it's paraphrased, and I'm curious about the quotes. I don't know. It could be that it supports your place, but I'm trying to figure out what specific language.
Yes, sir. Well, if you're asking me for a quote, Judge, I might have to hunt through my brief.
That's my. I'm searching through the brief, so I'm looking for some specific language that would suggest that, if a accumulation order is insufficient, the Court of Appeals is required to delete that from the judgment, and it cannot be sent back for clarification. That's what I'm looking for. And, maybe it's there. I'm having a difficult time finding it myself.
Judge, I might need to process that for a second.
Okay. I don't want to disrupt your whole argument, so carry on. That's one question that I have in studying the briefs in the case.
To pivot off your question, though, Judge, one of the main things that the state brought up is that the case law, they're arguing that the case law implies improper stacking orders are unassailable on appeal. Well, that's not true. The thing that's not assailable on appeal is when a case is properly stacked. And so here, what we argued below was that there was an abuse of discretion. The judge's authority under 42A was never triggered to stack. And that is assailable on appeal because there has to be facts in the record to support any judicial decision or order. Due process requires judicial action to be supported by some sort of facts or evidence. And I believe that's the, we cite a Supreme Court case about that, and we also cite several cases about that in our briefs.
Why? I'm also curious about this. So the defendant is standing, in my experience, being in courtrooms, when the defendant is sentenced, he's standing right in front of the bench. And so he's hearing the judge say, in this case, for example, I'm sentencing you to this, I'm stacking this sentence upon the sentence in this cause number. And by the way, if that's not enough information for you, it's the one where you were convicted of this other specific crime. And the defendant says nothing, but the defendant, surely he's on notice at that point that the sentence in this case is not beginning today, right? He's being told by the judge that it's only going to start whenever some other sentence is over. And so wouldn't it behoove the defendant, if he was curious to know about which, if he's not satisfied that he knows which conviction it's being stacked on, to say, well, Judge, which one is that again? I don't know that you're having specified that one crime, and given that cause number is enough for me to digest, maybe I've got a whole stack of convictions, but, I mean, how, shouldn't he have to say something at that point? Which one are you talking about, Judge? I mean, and also I'm sorry to go on and on like this, because I just have a lot of questions. I really want the answers. Why is it that he's not on notice, at least, that the sentence isn't starting today as it normally would when it's pronounced in open court?
Well, Judge, Ex parte Hernandez specifically stated that improper accumulation orders are automatically concurrent.
Ex parte Hernandez. Okay, well, maybe that's the case I'm looking for. I have to look at that.
And that's 758 Southwest 2nd 594, I believe. And so, in that sense, the appeal and reformation remedy is really a formality. And I believe it's page 54 of the court's record, even the judgment itself in this case contradicts itself. It says the sentence starts today, if the court was to look at the judgment itself. And then it also has the little section where it says the cause number that it's supposedly being stacked with. But also, what's interesting is it's difficult to create or to object to something when you don't have all the information. So the verbal pronouncement, as we know, typically controls in a criminal case. And so when the verbal pronouncement itself is improper and it's supposed to automatically be a concurrent sentence, at that point, there's not really much to object to. But also you require the full record to identify what evidentiary or factual issues you're going to appeal under, which in this case, it took some time to get the written judgment in the record. For example, I believe that the accused himself wasn't even thumbprinted on the judgment until 6 or 7 days later. And so the state seeks to analogize this scheme to a remedy associated with restitution, and that's not really proper either, because that statutory scheme imposes burdens, whereas this one does not. There's a burden on each party under the restitution scheme to present evidence, whereas there's no burden for the defendant to do anything. I would say imposing a burden would violate his right to remain silent.
But we do impose burdens on defendants to object when they see an error happening. I mean, that's not foreign to the system. I mean, I grant you, you don't have a burden. No defendant has a burden to show that he's innocent of the crime or that he's not guilty or that, the state has all that burden. But there is a burden to object when something seems not right that's going on in front of the court that could cause detriment to the defendant. Let's say the admission of evidence or a sentence that's illegal, for example. I suppose you wouldn't have a burden there. That's no burden. But there are other situations in which the defendant would need to object, correct?
There might be some, Judge, but I think in this case, because it's been tied to a Category 2 Marin right that requires an express waiver, that would require some deep constitutional revisiting of the case law.
And that's Ex parte Hernandez, correct?
That case is Ex parte Carter, Judge, but it's also tied to McJunkins. I don't have the reporter citation with me on that one. And there's also issues here of reversible error. A lot of times objections tied to reversible error, and the court has repeatedly said this is not reversible error. It's just error that's corrected on appeal by supplementing the accumulation order with other information in the record or striking it. And so, with that, the state seeks to supplement evidentiary shortfalls by utilizing software such as TAMES. That's one of the big arguments they make. And TAMES is a system that's subject to human error, tampering. We've seen what happens when governments are hacked and their software goes down or has problems. And we're also in the age of AI. AI is kind of scary. AI creates fake documents, it creates fake video, audio, photo, and we sanction lawyers for using AI to improperly write their briefs. And so I think that's a dangerous road to go down. I think all this precedent, it opens the door to remand for evidentiary things where the rules don't allow it, and I see I'm out of time.
Thank you, guys.
May it please the court. Good morning. I'm Mark Bennett. Judge Shearer, what is your understanding of the remedy that the state is of what the state's asking for? Because you said clarification. It appears to me that in the state's PDR they suggested that remand for clarification is the remedy, but in their brief they appear to have abandoned that and said that a nunc-pro-tunc judgment is obviously the best way to go. It's obviously not the best way to go, because a nunc-pro-tunc judgment is to correct not a judicial error where the judge orders something with no evidence, but rather a clerical error where the judge orders something and then the clerk writes a judgment that says something different. This is not a clerical error. This is a judicial error. And so the remedy that the state proposes, which in its brief, not perhaps in its petition, but in its brief, which is nunc-pro-tunc, is simply inappropriate. This court, sorry?
I'm sorry, is this part of a sentence? Is this something
No.
that, okay.
No. And this court can no more, well, let me say that if the trial court could enter a nunc-pro-tunc order because the evidence supported it and the judge said the right thing but the clerk said the wrong thing, then this court could certainly reform the judgment. And I think we've seen cases, I think they're briefed here, in which this court or other courts of appeals have reformed stacking orders because the judge said one thing in court, which is the operative fact, what the judge said in court, but then the written judgment said something different. So
The proper remedy then, according to you, is what?
the proper remedy is to strike the cumulation order, and that is Ex parte Hernandez. It's at page 50, I think 53 of our brief. And I was thinking about this yesterday and thinking, well, why, Mark? Why? I mean, these judges are going to ask you, why is this the right rule? And I thought about law and economics, and I thought about how the rule that we're defending here is that an order, not just accumulation order, but any order, has to be specific enough that people understand it just from the face of the order, and they don't have to go to Thames to figure out what the order intended. Well, why is that? Because an order that is not that specific is inefficient. It's a drag on society. It causes problems. And do we know what the specific problems are? No, we don't know what the specific problems are. It's a magic spell. And if the spell is not written right, what goes wrong? We don't necessarily know what goes wrong with the magic spell. But under the law and economics evaluation of this, there's this inefficiency, and somebody has to be incentivized to fix the inefficiency.
Well, did you hear I had a hypothetical earlier where a judge pronounces sentence on second-degree felony and he says years in the TDCJ. We would send that back, wouldn't we, to redo it?
I think that's an illegal sentence. I think it would be reversed. I think it would be remanded for a new punishment hearing.
I mean, is it illegal or is it just deficient and vague? Because it says years. I mean, it could be that it's legal if it only meant 2 years or if he only meant 5 years, but...
I think it's an illegal sentence.
Okay.
Even if it's not an illegal sentence, however, I think the remedy there is to send it back for a new punishment hearing, which is clearly not the remedy in this case. Where nobody's
Speaking of inefficiency, to do the whole hearing over again? Because
in that case, right, where the judge has, and this is the rules which came from Wilson's form book. And I talk about that in my brief, and it was really enjoyable for me because I got to dig down into that Texas legal history. But the rule on what the order should contain, which is based on the common law rule that orders have to be specific in order to be enforceable, which we see in other areas, such as injunctions and orders enforceable by contempt. But I just lost my place. Anyway, but the rules from Wilson's form book that everything has to be identified in the judgment has been the rule for 135 years explicitly. And so judges should know this.
It's in the statute.
Trial court judges should know this. What?
it's in the statute that you're supposed to put that in there.
It's not in the statute, but the courts have been talking about this for 135 years, and trial courts should know it, and prosecutors should know it. And if a judge says something that doesn't follow what everybody ought to know the order has to say, then there are two people in the courtroom who have an interest in actually pointing it out. The prosecutor could say, Judge, we're going to need you to take judicial notice of the judgment. Okay, I propose to take judicial notice of the judgment. We have a procedure for this. Defense, do you object to me taking judicial notice of this judgment? Yeah, Judge, we object. Why do you object? I don't know. We object. Okay, I'm going to take judicial notice of the judgment, and I'm going to stack this sentence atop that judgment. The state has a motivation to do this at that time. The court, the trial court, should know this and should have the motivation to do it at that time. But under the law and economics analysis, the only way that we eliminate this inefficiency is to allow the defendant to challenge the judgment and to strike that contempt order, strike that cumulation order if the cumulation order is invalid, which is how the law has evolved. Yes?
Specifically, what is it that the trial judge left out that makes this an inappropriate sentence?
What would have been
What element?
What would have been, well, any of several other things. The judge could have said, I recognize you as the person who I sentenced in this other case, and I'm going to stack this judgment atop that one. That would probably be good enough. If the judge had said the county of the other judgment, then that probably would have been good enough, because somebody then looking at the judgment could tell, okay, it's this case number in this county, and in most counties there are not separate, you're not going to have two case numbers from separate courts that are the same case number.
Why does he have to say, I recognize you as a defendant I previously sentenced? Because he may have forgotten it, but certainly the defendant would not have forgotten it.
Well, because the record, one of these common law principles that we're defending is that orders have to be supported by evidence. And my brother from the state says, well, a lawful order is unassailable. Well, lawful is not a description of every order. An order that is lawful is unassailable, but you can't determine whether the order is lawful or not without assailing it, without appealing it. So what got left out is enough, what needs to be done for the sake of, and it's been this way forever, and what we're proposing is simply continuing to follow the law as it was when the Texas Constitution was written, which is that orders have to be specific. Why do they have to be specific? Well, I mean, the defendant is the one who gets to appeal it. The defendant is given the remedy, but the underlying reason for that is that nonspecific orders are inefficient.
So could we go back to Judge Richardson's question about what more needed to be in?
The county would have done it, because then if you had the county and the cause number, that would have been enough. The judge taking judicial notice that this was the same defendant probably would have done it. I recognize that you were the person that I sentenced in cause number XYZ, and I'm stacking this atop that.
Did he not say something like, and I can't quote it, but the one in which you were convicted of this kind of crime?
Yes.
He said child pornography.
Okay.
So yes, and it's not enough. If you can look at it and you can say, well, it is not unimaginable that there are two of these sets of facts that are declared in the order and in the judgment that are different people, then it's not sufficient.
But it gave a cause number too.
Right, so yes, and these cause numbers are recycled. Lots of different counties, I think 9 different counties I listed in our brief use the same sort of cause numbers. So just the cause number and just the sort of case and just the name, cause number, sort of case could very well be repeated in different counties and could be different people. And unfortunately, TDCJ, if we put the burden on them to cure the inefficiency, which itself is an inefficiency, requiring somebody outside the judgment to decide how the judgment should be interpreted, could conceivably get it wrong.
So 9 different counties would have a guy with the same name and the same cause number with the same offense?
Not necessarily, but it's conceivable that there could be 2 people in 2 of these counties who have the same cause number, the same name, and the same offense. And so the specificity would require that not be a possibility, and that it be shown from the face of the document, from the order, that it not be a possibility. And here, it is a possibility. Here, how could the judge have prevented that from being a possibility? Well, if this is the case that the state has found in Thames, then the judge could have said, in this court, in this county, and that would have solved the problem. The state could have made this objection at the time, could have fixed the problem, and we wouldn't be here. We pray that this court affirm the judgment of the Court of Appeals maintain stare decisis in Texas and keep the rules as the common law requires them to be. Thank you.
counsel.
May it please the court. I don't know how many convictions for possession of child pornography with that cause number appellant has, but if it's more than one, that would have been the time to say something about it, and we could have gotten this straightened out.
Let me ask you about that. Let's assume there were a couple of convictions. One had a shorter sentence, one had a longer sentence. You may have addressed this, I don't remember. And in the trial court, the defendant thinks, oh, he's stacking it on the shorter sentence, but the judge really means to stack it on the longer sentence. How does he get relief?
That would be in a writ. And Ex parte San Miguel from 1998 covers this, that the real interest that a defendant has is not having an order that's specific enough or having evidence at the hearing that would support it if pushed on direct appeal. It's not being incarcerated longer than you're supposed to be. So your problem doesn't come about until you think you've finished a sentence and you're supposed to be released, and you haven't been released.
Okay, then what does he do?
And then what San Miguel says is you file the writ and you say, hey, I have this order, and this order is wrong, it was improperly filed, I should be released because I'm not properly stacked here. And the burden's on him, partially because of the procedural setup of a writ, to make the record clear that that's not what was supposed to happen. This sentence was supposed to have been served concurrently. In that case, it was, he'd think that the order was void entirely. In your hypothetical, it would be, I should have started serving this sentence 8 years ago instead of today, so I should only have 2 years left. So really, he can't complain until the 2-year point where he thinks he should be released, and then he's being illegally incarcerated. Does that answer your question?
Yes, thank you.
A lot of the conversation we've had,
Raise a latches issue if you wait too long.
well, he doesn't realize that he's going to be incarcerated longer until that date. But, and this is the fix that they have themselves in. If this is something that you can raise for the first time on appeal and it's statutory, you shouldn't be raising it in a writ anyway. So you couldn't be complaining about some impropriety until you're illegally incarcerated. So I don't think this is a scenario where latches is going to create a problem. You may have other burdens before that time or other problems with raising it with cognizability. One of the things opposing counsel was talking about is the lawfulness of it. And in this context, lawful is a term of art. Lawful means not in violation of the authorizing statute. Authority comes from the authorizing statute. So all the cases he's referring to, Carter, going back through LaPorte, going back to McJunkins, which is 954 Southwest 2nd 39, if you're interested, they're talking about clear violations of Section 303, where you have a defendant who's tried for multiple offenses arising out of a single criminal episode. He's tried in a single criminal action. His offenses aren't on the list of things that you can stack, notwithstanding consolidation, and the judge does it anyway. This court has said that is a Category 2 right. You can do that if you want to, and as part of a plea, that may be necessary to do, and one of the I think Carter may be a waiver case, but that's the context we're talking about, where it's very clear on the face of it that 303 was violated and no judge has any authority to stack these sentences. That's not what we have here, and Barrow and Beattie make it clear that when you have a case that has one of these problems, there could be more evidence in the record to prove up the prior conviction. The judgment could be more specific, that you don't have a lawful problem, you have a more traditional problem that this court has been doing for years. I don't know that I've read a case that says you have to strike the order. I just know that that's what's been done forever. So,
You're familiar with Chesterton's fence. I think it might have been referenced in one of the briefs.
yes.
If we take down a fence and you don't know why it's there and it was there to keep the cows in, then all the cows might come out. Is there do you foresee any kind of disruption to the system that might occur if we were to
I think
follow your recommendation?
Your analogy is an apt one. Stacking is designed to keep the cows in. In this case, it's designed to keep multiple felons, in this case, in. And there's a stacking order. Opposing counsel talked about there being a drag on society if we're not clarifying orders, if we're not striking these orders. The drag on society is when somebody's supposed to be in prison for another 10 years and he's walking around with the rest of us. And that's the burden.
Let me ask you a question. Mr. Bennett said he asked himself last night, I think, why should we strike this improper accumulation order? So I asked myself the same thing. And my first thought, and you tell me if you agree with this, is that stacking orders can have pretty severe consequences to defendant. Isn't that correct?
That's the point.
And those severe consequences, you know, could be adding 20 years to somebody's sentence.
99 years, sure.
Time he's going to be in jail. Well, I think because of the severe consequences involved, a trial judge should actually know something about another case before he stacks this case on top of it. And this stacking, what the judge said, made me think he didn't know anything. He wasn't even sure there was another case. And that's why we should create a law where it's much more specific. The judge needs to show that at least he knows something about a case that he's stacking another case on top of.
Well, I'll disagree with your premise and your rationale. At no point should this court be creating a law that creates better policy than they think the legislature has set in place. And I think Judge Bufkin made it clear, you have a prior conviction for child pornography. He was guessing at the cause number from memory. He was correct about it. So I don't think the record fairly shows a judge who's just flippantly saying, hey, if you're already in prison, and I have no idea, after all, I'd be the one who would have signed the order bringing you back for trial, but if you're in prison for something, let's just stack it. This wasn't a flippant decision. This was somebody who gave the defendant enough opportunity to say, I've properly served that, or I have multiple sentences, and could you please make this more clear? But trying to impose a law that's not required by law is just not something this court's able to do.
Okay, thank you.
Thank you.
Thank you, counsel. The case is submitted. Call now for cause number PD 056423, William Solomon Lewis versus the state of Texas.
Good morning. My name is Zachary Gibson for the state. I hope y'all can hear me this time. Presiding Judge Keller, may it please the court.
Feel free to speak louder.
Okay, yes.
Please.
Presiding Judge Keller, and may it please the court, this case involves two grounds of review because the lower court committed two different errors. Although different, both, however, stem from the same root problem: an overly crabbed and picky appellate scrutiny of an otherwise valid criminal conviction. The holdings of the lower court below flouted both this court's directive to view the evidence in the light most favorable to the verdict and this court's directive to interpret legislative enactments according to a fair and reasonable reading of the text. The court below begins its error by holding that a rational jury could not infer that a man who wants to kill his own mother, who has testified against him at a protective order hearing, and who plans to testify against him at a trial about the same underlying facts, was doing so in retaliation for or on account of her testimony at a prior proceeding. The court reaches that conclusion by putting almost dispositive weight on the appellate's own stated motivation. This is the opposite of how other sufficiency review works in all other contexts. As many courts have noted, intent may be proven by a circumstantial evidence, and in fact, it is rarely established by other means. The Second Circuit has noted in interpreting the federal retaliation statute that direct evidence of retaliatory intent is rarely available to prosecuting attorneys. The lower court did not view the evidence in the light most favorable to the verdict when it refused to factor in basic and well-known motives of criminals and indeed most people. The lower court then compounded its error by reading the word witness, which has appeared in similar statutes going back to Blackstone, as meaning a person whose testimony is anticipated in court, in an artificially limited way of only meaning someone who has testified in an official proceeding. When one looks at the plain meaning of the word both witness and status, it becomes obvious that the lower court did not give the statute its fair readings. On both grounds, this court should reverse.
Let me ask you a question about that, because, ordinarily, when a statute, when a term in a statute is not defined by the statute itself, it's given its ordinary meaning. But what happens when the legislature comes in subsequent to interpretations by this court that might put guardrails around the term witness, and then says, well, they add another word to it, right? Like a prospective witness. Does that necessarily mean that to the degree that the term witness might have originally properly contained prospective witness as well, now it doesn't because the legislature has added that new term, prospective witness, specifically?
Well, it does. So let me answer your question yes and no. So in Jones, we concede in our brief that there is language in both Jones and in a subsequent case, Benson, that could be read that way, that witness in and of itself means somebody who has testified. If that is what it meant, then the court was going against authority from Maine to California, from Blackstone to the present. However, here's what Jones actually said. Furthermore, considering the requirement of Section 3606 supra, which is the retaliation statute, the prescribed conduct be in retaliation for or on account of the service of another as a witness, we must construe witness to mean one who has testified in an official proceeding. The court was interpreting or giving a definition for what it means to render service as a witness. That's the most intelligent way to interpret it. So here the question isn't just have they added prospective witness, they certainly did. They've also added the word status. I mean, the legislature has not always consistent about many things, but if there's one thing they're consistent on, they keep broadening it and broadening it and broadening it and broadening it. They want this to be broad, and they don't want picky, I'm going to read the statute and the evidence in the most uptight way possible. They want it to cover people.
So is the element, the substantive element in this statute, is it witness, or is it public servant, witness, prospective witness, or informant? You see what I'm saying? Is that sort of a substantive element with all those options?
Well, it would be an element with those different options. They would be different manner and means. Now, with manner and means, they have to be supported by the evidence. In many cases where it's clear only, certain manner and means apply, you either just plead the ones that apply, or you maybe plead them but then wait until it goes to the jury charge, and if there's no evidence of something, then you wouldn't submit it. Like if you have a DWI case and all the evidence is about alcohol, you may just have the generic intoxicated, but then in the jury charge you would just have by introduction of alcohol, because there'd be no evidence of drugs. I mean, it would be purely speculative. So it's I think Kata called it a Chinese menu. But to be clear, there are two issues here. One is evidentiary sufficiency, the first ground, where even if you assume the lower court statutory reading is right, we still win. I mean, this is but as to the statutory interpretation, this is about if you're assuming that they're right about the evidentiary view, this would be whether she had the status of a witness. And she clearly did. I mean, witness has been used, it's used in everyday parlance, but between attorneys, so I'm using the legal definition of the term witness, is somebody who, it does mean somebody who testifies in an official proceeding. The case cited, Ulmer, that's all it says. It doesn't say has testified. In the tampering statute before it, it says somebody who is a witness. It does say prospective witness in one place, but then in the next section it says just witness. A person who commits an offense if with intent to influence the witness, he offers, confers, etc., a witness or prospective witness. So witness is generically a term that can be used to talk about somebody who's going to testify, who is testifying, who has testifying. The context is what shows whether it's, I mean, nouns do not have tenses, so you have to, it's based on context.
Page 1 of the Court of Appeals opinion describes the problem in this case as a fatal variance. But it then goes on to say that the evidence is legally insufficient. And I'm curious whether, is there a distinction between those two things? If it's a fatal, is the court signaling that it doesn't really know whether it's a fatal variance problem or a sufficiency of the evidence problem? And if so, like, what is the problem? I mean, is it a legal sufficiency or is it a variance between, you know, what was sort of a notice problem? Is it a notice problem or a sufficiency problem?
It would be,
And
first of all, I'm
the
not,
Court of Appeals having used the word variance, fatal variance, in the first page of its opinion?
well, I certainly will not defend the conclusion of the lower court, but if something is a fatal variance, so I believe, Judge Shearer, correct me if I'm wrong, you wrote the majority opinion in Ram Johnson Singh, that's a difficult word to say, where it talks about where something rises to the level of a variance that affects legal sufficiency. Their whole theory was there isn't sufficient evidence that he had this intent based on past testimony. Now, we think that's somewhat ridiculous given the record, but that was their theory. And then the next thing is a fatal variance based on a, quote, distinct statutory term. And he is using the term fatal variance to refer to a problem with sufficiency of the evidence. We don't think it applies here. But I think that kind of fatal variance, according to Cotta, does affect the sufficiency of the evidence, if that answers your question. If it were just a variance of something with manner and means, but it weren't a statutory one, if it were just like how you punch somebody in an assault, that would probably be a non-fatal variance. But back to the issue of the statutory interpretation, our argument is not just about the meaning of witness, it's about what status does to it. People have, I mean, it's been used in obstruction statutes. Blackstone used it, the predecessor to, I think it's section 1503, where they used to prosecute people for witness tampering, intimidation, retaliation, just use witness. And that was considered to cover people who were going to testify, people who have, because the context of these types of statutes, sometimes the proceeding or thing you're trying to obstruct could be in the future, or it could be retaliation for something in the past. As to the evidentiary sufficiency, the other problem with this case, onto the first ground of review, getting away from the statutory issue, is what it does to sufficiency of the evidence. And I think the best analogy is to a visual force perspective. This is forced evidentiary perspective. Yes, it is true, and we certainly concede that on the first ground where you assume that this needs to be directed at past testimony, it's true. The evidence that he has the intent to probably tamper and also retaliate because she's going to testify, that is overwhelming. I mean, it is, you know, to the moon and back, because he confesses. He gives an explicit confession of his intent when he's on the jail call. The problem is, if he had just given, and we cite, it's cited on page 16 of our brief, United States versus Johnson. It's a federal case, but it's where they have somebody where there's an attack on a witness's mother, and the person never says what their motive is, and the court's like, well, it's rational to presume that it's both. It's both retaliatory for the past testimony. I think he testified in front of a grand jury, and also because he was planning on testifying at trial. Those are just normal human impulses. Yes, it's true that here you have the explicit confession. Now, first of all, defendants don't normally get to confess what their mental state is and force juries to believe it. I mean, if that were the case, they would have very difficulty getting a conviction. But also, assuming that he had the mental state are not mutually exclusive, right? I could imagine a case where if you have one mental state and the evidence of that is overwhelming, that yes, you could not then go forward on another mental state. But here it's perfectly rational to think that, yes, he was furious she was going to testify against him. He was also angry that she had testified against him in the past. He knew about her testimony. It was based on the exact same underlying facts that was part of the harassment case. He moved to quash the protective order. I mean, just basic human motivations of criminals and people that are in the legal system. I don't know if you could say that a person getting a protective order is less likely to get retaliation than somebody that's getting testified against in a criminal trial. Most family law attorneys would probably not agree with that. So there is legally sufficient evidence of that he had the retaliatory intent against the past testimony. It is circumstantial. And yes, one might be here and the other's here, but it's still, you know, they're still tall enough to ride the amusement park ride just because somebody else is much taller. As to the statutory ground, I was covered it earlier in my conversation with Judge Yeary. The federal courts all interpreted witness to mean somebody who is going to testify, who is testifying, who has testified, because the context of obstruction of justice statutes is absolutely that those things are covered. In Jones, the court made very clear that it was interpreting that term along with service. And yes, somebody does need to have testified to an extent to serve as a witness. But having the word status, in fact, it is on page 44 of our brief, United States versus Davis. It's a federal case, and they're talking about the federal obstruction statute, the former version, and they use the word status, a witness's status. Status, in our view, is literally just nothing more than the use of the word to be. Somebody would say so-and-so is a witness in a case.
Is that something that, I'm just curious, I don't know the answer, is that something that has always been in the statute from the beginning, service or status, or is that something that came along later in some amendment to the language?
It did. It was added, I believe, in 1997. So it's
Both
been
words were added, or only one was? Did it start with one and?
well. It started out in the 1980 version. It was service of a witness,
Okay.
and then in 1983 they added prospective witness, and then in 97 they added service or status. So now it's service or status of a witness. And the case that he relies on, Cotta, yes, was after the 97 amendments, but the state in Cotta, they apparently were using a very old pleading manual. They literally just charged based on his service as a witness. Also, Cotta is not really on point either, because any discussion in Cotta about the difference between a witness versus prospective witness is all dicta. The court said that the person there met neither definition. It was there the only definition you could reach under the facts of Cotta without speculating would have been that the person was an informant, because he was the defendant was angry that the person had called the police and a warrant had been found against the guy's wife, but that was it. There was no reason to think he would ever testify in court in any reason. So I see I'm out of time. I'm eating into my rebuttal. Thank you all very much.
May it please the court. My name is Mark Hochglaube. I represent William Solomon Lewis. What Mr. Gibson just told you is flat out wrong about CATA not applying or not having a holding that applies to the distinction between a witness and a prospective witness. I think the second sentence in CATA, and I'm quoting here, we hold that a variance between the pleading of one statutory element, a witness, and proof of another statutory element, a prospective witness or an informant, is material under Galahar. I mean, it just could not be more clear how CATA speaks to this particular set of factual circumstances. And, you know, to use a sort of cliche that we hear in law school a lot, we talk about attorneys pounding the law or pounding the facts or pounding the table. I would readily acknowledge that the facts in this case are ugly, and that the facts are not on Appellant's side. What he said was reprehensible, and it is difficult to resist the temptation to want to see him held accountable. And so I would readily acknowledge the facts lie with the state. But just as decisively, the law is on the side of appellant. This is a clear case where there's a generation of case law holding that a specific definition applies to witness.
What is that definition that applies, and where does it come from?
It emanates from Jones, and the definition is a person who has testified.
And does that go to the jury? Do they get that definition?
Well, I don't think it necessarily does, but it certainly could be requested, and then the jury would get that definition.
Well, I mean, if looking, in legal sufficiency, you only are gonna say it's insufficient if no rational jury could have found. And you have to have the hypothetically correct jury charge to see what they should have been looking at. So must they get that definition from Jones? And if not, how would they know that the evidence really wasn't there?
Well, in this case, the defense did ask for that definition to be included. And my understanding, offhand, I don't know that I've double-checked the jury instructions to know what the jury received in this case. But it makes sense that it would have been included based on the conversations that I was reading last night. So I think the jury would have received that definition. And I think that it would have been clear to the jury in this case that the singular defense that the defendant was offering was that he had not threatened a witness, but that he had threatened a prospective witness. If that answers your question.
So you're saying that the jury charge should have said witness means somebody who has testified?
Yes, ma'am.
Was there an objection on that basis to the jury charge, or I'm just curious?
My understanding is that there was not I'm trying to recollect. I know it's in volume 16, the exact language of what the disputes were about the jury charge, but I know that the defense asked for an instruction defining the term witness, because...
But even if they didn't get that instruction, you're saying they should have gotten that instruction, and that's what we should measure the sufficiency of the evidence against?
Yes, ma'am.
That legal definition of witness that comes from Jones?
Yes, ma'am. And to your question, Judge Erie, I would describe a variance as a form of insufficient evidence. Right? I mean, there's lots of different ways that the evidence could be insufficient. It could be that all of the witnesses who testified were not credible.
Well, you can have a variance that's not a fatal variance, but nevertheless a variance. It's you proved something that you didn't allege, and you don't acquit somebody on that basis always, especially if it's not a fatal one, right?
For sure.
So, so that's what it makes me curious. Usually when you say the evidence is legally insufficient, for some reason, it's an acquittal, period. So that makes me wonder about what is this distinction between variance that we've recognized and legal sufficiency itself, like substantively failed to prove the elements of the crime.
And I would say that Cata is exactly the instructive case. Galahar makes clear that surplusage and non-elemental variances won't result in an acquittal on appeal. But when there's a variance that goes directly to an element of the offense, in this case, the protected individual of a retaliation charge, right? In that situation, that becomes a fatal variance because what has been alleged is one particular element, and what's been proven is a specifically different element. And I would also submit that on the legal sufficiency points that the state thinks it's so obvious that this protective order was a contributing factor. I would urge the court just to review the transcript. And Justice Harvey, the state sort of relies on a case called Flores, in which Your Honor wrote a dissent, basically. And the state deduces from this that the only time you can really deduce a person's intent is when they confess. That's what this phone call is. I mean, basically, the state just said he confessed. I mean, he confesses, it's just he confesses to a specifically different illegal intent. And he is emphatic about it, and the reason why is because he doesn't want to go back to federal prison. And he's constantly talking about how this new charge of harassment against his mother has criminal implications that are liable to thwart his federal supervision. Whereas a protective order from months earlier, which although the state says that he was aware of the testimony, he wasn't aware of the testimony. He was aware that there was a protective order, but he was not aware that she had testified in it.
What do you make of the difference of the words service or status? The state pointed out that there's potential that these words mean different things, perhaps, and I'm wondering, how does that fit into your argument? That this language within the statute, I think within the charging instrument as well. Tell me if I'm wrong about that, but service or status.
Both are included in the charging.
Okay, so are those different things, and can you explain what the difference is as you understand them?
Well, so I think, and this court has held that service and status as applied to prospective witness, which is not what's pled here, as applied to prospective witness, that basically there's no difference.
Well, but is that what our opinion said?
It is.
We said we were addressing under the terms service or status.
In Ortiz.
Not just service.
Correct. In Ortiz, service and status are both alleged in conjunction with prospective witness. And this court holds that basically it says there's little difference, but the inference to be taken is that there's not a difference, right, between those two as applied to prospective witness. But the court also says that service and status as applied to every other person or protected person under the statute, that there is a difference, or it basically suggests that. That's what the language suggests, is that prospective witness is the only type of protected person where service and status are the same.
I mean, I can see how you could say somebody has not served as a witness if they have yet to testify, right?
That's
I
correct.
can see that. If you have the status of a witness, that's a more difficult problem, because even in this case, you have testimony from someone saying, I think the officer saying that this person is, as in like now, the complaining witness, right?
Yes, sir.
So that means, I mean, to some degree, that person is a witness.
Well-
Do they have the status of a witness, perhaps because they are the complaining witness? Or
I do not dispute that the
Okay.
word witness, certainly in common parlance, is far broader than the definition that Jones gives it. But
no, but I mean, does the word status enhance our understanding of what a witness can be?
And I would say no, because if you look at what the sort of evolution of this line of case law, right, the first change is that Jones comes along and says witness is only to be a person who has testified. And it's exactly to your point, based on the fact that at the time, service was the only possibility. And for a witness to have served, they must have testified. Right? And Jones makes that part clear. In response, and this court has held it specifically responding to the Jones opinion, the legislature adds the contradistinctive term prospective witness. And what you find is that then, about 15 years later, the legislature adds not just service, but it adds status to it. And the legislative history makes clear that the reason for that adjustment had nothing to do with witness or prospective witness at all. It was based on the fact that they wanted to alter they wanted for public servant, which is another type of protected person, right? They wanted to be able to prosecute cases when a public servant status or a public servant's service was involved. But
So if the term status is defined, would be defined to include someone expected to testify, that would render the term prospective witness
totally obsolete.
would be, yeah.
Completely obsolete. And this is to the questions you've been asking all morning about what kind of language does this cause problems with in prior cases. Throughout all of the cases involved here, from we talk about Jones and Benton and Morrow and Ortiz and Cata, every single time this court speaks to this issue, it says that each of these items, prospective witness, witness, public servant, is distinct.
So if the state had just pled witness, we might be in a different place?
If they had pled prospective witness.
Okay.
If they had pled prospective witness, we wouldn't be here. But additionally, I mean, just to reemphasize how clearly CATA is on point, right? The whole reason why the defendant, and anybody who looks at this case will see that my client is a litigious individual, and the volumes I think are 30-something in nature because there were constant hearings and whatnot, and there's Ferretta hearings and whatnot. He's the one who identified this. He's the one who actually read this court's opinion in CATA. And unfortunately, the prosecutors did not. And if they had, undoubtedly, they would have pled this case differently. And this is what's sort of, troubling to me as I read this. The solution here is not to rework, a half a century of jurisprudence. The solution here is for prosecutors to plead their cases correctly. That's what, this was just a mistake on the part of the prosecutors.
So
And-
counsel, you talked earlier about elements, and you talked about proving one element, but the other element has another element. Is your theory here that a further, let's say we say, okay, fatal variance, insufficient evidence, would a subsequent prosecution of your client for a prospective witness be jeopardy barred?
Well, it would not be jeopardy barred. At this point, it would be barred by the statute of limitations.
Okay.
But it would not be jeopardy barred. At least, and I'm not sure I've thought to that, but they are different elements under Blockberger. They're just being disparate elements. It would seem to me that the charge would not be
Is there any
jeopardy barred.
limitation on the legislative, on the legislature such that they cannot define or provide options for elements of an offense that have overlap? Can they do that? I mean, I'm thinking about in my
Absolutely.
mind like a situation where somebody is both over the age of 65, so they're elderly, and they're also disabled, right? And let's say that the evidence shows one but not the other, and both of them in this hypothetical statute I'm thinking of are different options, right? So I'm wondering if you could be both, in some sense, a witness and a prospective witness at the same time, such that the jury could, even though you didn't plead prospective witness, and there's one sense in which you might be only a prospective witness, there may be another sense in which you already are a witness at the same time.
And I don't quarrel with the idea that there's overlap. In fact, all of the cases from this court suggest that there is overlap. That's what Ortiz says about, status and service of a prospective witness basically being the same, just as those two words cover to prospective witness. The problem is that all of these words have to have at least some distinction. There has to be a place where they are distinct. And
So they have to be different.
well, there has to, I would submit that if you're gonna assume the legislature had an intention when it added the language prospective witness, then you have to give that meaning. And that's, and it was made in contradistinctive, it was made as a contradistinctive category to witness, specifically because of this court's opinion in Jones.
Right. What if the state had what if the appellant had simply threatened to kill his mother and, there was without saying any indication why, just gonna kill her. I hate her, I'm gonna kill her. He didn't even say hate her, just gonna kill her. Do you think that would have changed the finding by the Court of Appeals as to sufficiency?
It might have. It might have. What is so striking about this phone call, and in many ways for worse, is just how specific he is, right? I mean, he is just spot on specific about asking about whether she's going to testify in the upcoming case, and asking about whether or not she realizes that this is going to send him back to federal prison, and asking, he does this repeatedly. There's no mention of some protective order. There's no mention of anything about the process that's happened in the past. It is all about what's happening in the future. And yes, he's mad at her for a litany of other reasons, although the protective order never comes up. but it is just the specificity with which his statement is repeatedly said, that he is specifically trying to address her future role as a prospective witness. And so to the extent that if he hadn't been so specific, if he'd just said, if he'd been out of custody somehow and he'd said, I want to kill my mom, then you get into questions of how does it connect. And I wanted to address this because I didn't include anything about this in my brief, but if you look at the causation statute, which is not exactly applicable because causation is whether a defendant is culpable when there's concurrent causes, right? But it's a really helpful sort of analysis because what it says is that when there's multiple causes, if the cause that's part of the charge could not have caused the result, but the concurrent cause could have on its own caused the result, then there's no culpability, right? And in this case, it is undoubtedly clear that it is the future testimony that is causing this threat. And that, undoubtedly the defendant and his mother had a very complicated relationship and tempestuous and problematic. And we can look at this from a butterfly effect analysis and go back to the time that he was an infant and was crying for his bottle, and how all of this ultimately led to where we are today. But when you talk about causation, and I would submit that the language of the retaliation statute goes beyond just normal causation because it speaks to on account of and in retaliation for. It is a very quid pro quo type of analysis. And when you're speaking to that, there has to be a causal nexus between the actual intent of the person and the service or status of that person's role in their protected category.
Does this boil down to only an issue of failure of the state's pleadings, or is it something about which the defendant didn't have sufficient notice? You see what I'm saying?
I do. I don't think this is about notice, Judge.
You think he kind of knew what they were coming after him for?
What I think is that the defendant looked at this pleading, looked at this court's opinion from Cata, right, and concluded that what he was charged with was not what he had done. Mm-hmm. And I think that ultimately when they got to the court and the defense initially made its motion for an instructive verdict, that everybody in the courtroom, the state included, agreed that based on Cata, the state's initial presentation of the evidence had been misguided and that they had pled it incorrectly. And the state, a couple times on the record, acknowledges we made a mistake in our pleading. And that was the singular basis of his defense, and that's why we're here.
Quick question. This is the case where the mother posted a cash bond for, is he still out of custody?
He is at large.
Okay, thank you. Thank you.
Thank you very much.
All right. A couple things. Mr. Hochglaube's comments were that the state was completely wrong about something. Let me just read to you from Cata. In the present case, the state alleged that appellant retaliated against Mr. Finch on account of the service of the said Arthur Finch as a witness. And then it goes on to say, under Jones, the state was required to prove that Mr. Finch has testified in an official proceeding. We do not take issue with that. This case is about what it means to have the status of a witness. There is no holding of this court that we are asking you all to overrule. All of the cases that he cites, Cata. Yes, Cata came temporally after the amendments, but the state did not put it to use. Cata, Benson, Jones, all three involved service of a witness. And Jones, as I mentioned earlier, specifically talked about the word service as being important to its interpretive directive. The other thing, too, is that you ask about the legislature using terms that overlap. Let me just make a very important point here. This is not a case of a statutory definition. So one of the leading treatises, reading law, this is section 36, definition sections are to be strictly followed, carefully followed, I think is the word it uses. If the legislature had written witness means somebody who has testified, yes, we would be locked in with that. In fact, it does that with the word informant. It does statutorily define informant that way. But here, we're dealing just with what is the ordinary meaning of witness. And Mr. Hochglaube said, well, in common parlance, it would be broader. Well, if in common parlance this would cover this, then the statute covers this. If the legislature wants to statutorily narrow just the word witness in and of itself to someone who has testified, it can do that. Instead, it's added the word status. And we cite the federal cases, examples of the Fifth Circuit case saying that somebody had the witness status when they met the longstanding definition of somebody who is going to testify. The rules of evidence do that. In the 600s talks about the sequestration of witnesses called the rule. Well, that applies to both people who have testified, if you invoke it after trial begins, and people who have not, and they're all called witnesses. Nobody is at a loss to what they're having the status of witness is.
Are you agreeing that the correct jury charge should have said that a witness is somebody who has already testified?
If it had just had the word service in it and not had the word status, we would agree with that statement. At the very end of our brief, and I don't know if the court needs to go this far because I think this evidence is legally sufficient, even on the has testified. Yes, it's true, he confesses to a mental state, but they're not mutually exclusive. It's like if one person confesses to a murder, that doesn't undo the circumstantial evidence that he committed another one. We give the federal definition of somebody who is a witness under their broad statute just to mean somebody who knows or is supposed to know material facts and is expected to testify to them or be called on to testify. And that definition prevailed in federal court for over a century. And also, back to Judge Hervey's point about redundancy, this is a case not where you can interpret the statute not to be redundant. This is a case where you have to pick between redundancies or ineffectiveness, I think would be a better word. Do you want to make witness and prospective witness, they're not fully redundant, but when you pair them with status, in a sufficiency review, I don't think they would overlap as a practical matter. Or do you want to make service and status almost totally redundant of each other, even when applied to witness, even when there's a history of witness having a broader meaning? And if you're stuck on, well, we don't know what to do, well, the state legislature has said the penal code is to be interpreted broadly and fairly. It's to give a fair reading. There's other redundancies here too. It says if somebody wishes to retaliate for or on account of. Well, close your eyes and imagine a situation where somebody wants to retaliate for but isn't doing it on account of. I mean, it's in Pujon versus Garland, Justice Kavanaugh said that obstruction of justice statutes are just written this way. They're written with belt and suspenders, they're written broadly, they're written redundantly, because sometimes legislatures want to be doubly sure. Sometimes legislatures may not always expect courts to be the textualists that we all should be, so that can be another explanation. I see I'm out of time. Thank you all very much, unless there's further questions. Thank you.
The case is submitted.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.
Did you